So the next person we have up to speak today is Avnish Nanda, who's a local lawyer here in Edmonton, and is somebody who devotes so much of his time free, pro bono, picking up these issues and moving. I first met Avnish like 10 years ago when he came to me, and he wanted to kind of do some work with some of his colleagues around the bringing commemoration and reflecting on the Komagata Maru incident in the early 1900s. So the team's going to share a link in the chat with you around that book that came out of that work, because I think it's important. Regardless, it's not connected to what we're talking about here today directly, but important. So let's introduce you to Avnish. So Avnish is a litigator who practices law in Alberta and British Columbia, and there he is. Welcome, Avnish. And really was drawn to law out of his interest and involvement in social justice activism, which he has continued through his legal practice. He frequently acts for parties advancing civil liberties, human rights, Indigenous self-determination. I know we're often harassing him a lot about that. And outside of the law, Avnish serves on a number of nonprofit community boards and works on a range of public interest causes. Avnish is a sessional instructor in constitutional environmental law at the U of A's Faculty of Law. And he's a reader, a writer, active on social media. I encourage you to check him out because he's always got some good content going on that. So Avnish, thank you. You've been a beautiful person to work with over the years. I'm so excited to hear you this morning.
Thank you, Renee. I don't know how I can follow that introduction, but I really appreciate it and really appreciate the invitation to be with your group here to talk about a range of issues that I think fits nicely with what Marie-Josée had just indicated. But before I do, I do want to take some time to kind of recognize that I'm speaking to you from Treaty 6 territory, the traditional and current home and gathering place of numerous Indigenous peoples and nations, including the Cree, Blackfoot, Métis, Nakota Sioux, Iroquois, Dene, Ojibwe, Saulteaux, Inuit, and many others. It's a place that I'm proud to come from, proud to have been born and raised here. And as Renee mentioned, I'm a lawyer who works with many marginalized and vulnerable individuals facing a variety of challenges, including the prison and policing context, in the kind of social benefit and exclusion context, in a variety of different ways. But before I get into my work and specific cases where I've addressed a lot of the issues that the speakers over the course of this conference and even during this session have mentioned, I want to first discuss, what do we do as lawyers? You know, what do we do exactly in terms of the representation work? Why do we do it? And present a sort of a theory behind lawyers doing this type of work in particular. So I view the law as a public space. So think of a public park or a square in your community. It's like any public space, the law is something that is meant for us. It's meant to bind us together. We're all technically and theoretically able to access it in an equal manner. You know, we are all subject to it. And even broadly, the conceptual notion of law is that it regulates how we interact with each other, with the government, but we're all enveloped in it. But the reality is that though it touches us all and we're all within the scope of the law, we're not able to freely access this public space in an equal or equitable manner. For some people, there are many barriers that exist that prevent them from navigating this space to access the law. It doesn't work for them. And the barriers are such that it often excludes people, whether that's on gender, race, sexuality, indigeneity, class, and other identity markers. It's easy for some to find space to utilize this public space, while it's not the case for others. And in the history of this country, we've tended to have a public space in terms of the law that reflects certain communities, certain interests. And at the start of this country, and even to some extent now, it's reflected particularly white, Eurocentric, cisgender conception of what our society ought to be, and who's allowed here to make claims, to stake out rights, to be acknowledged and respected, even by our courts. So for someone like me, a lawyer who works with marginalized and vulnerable people, my job is one of translation and navigation, right? I work with vulnerable individuals to translate their lived experiences into the language of the law so that I can help them navigate this public space so that they can access justice. That's all I do, right? I work with people to speak the language of the law, to navigate both the conceptual and physical aspects of the law so that they can, through these systems, access justice, get the type of either compensation or relief that they need to live more just and dignified lives. And a lot of that involves storytelling, right? It's being able to understand and convey the lived experience of individuals, whether folks who are houseless, folks from different backgrounds, into the language of the law so that it is understood by decision makers who likely have never ever considered what life could be like on the streets or after experiencing such significant direct and intergenerational trauma, so that they can be understood and that this institution can provide my client what they need to live a better life. And during the course of my work over the last 8 years as a lawyer, I've come across a variety of stories on the intersection between poverty, criminalization, the legal system that illustrates how our society, how the legal system specifically continues to marginalize folks. It often creates the same injustices that it's tasked to address. And it prevents folks like my clients from fully flourishing within our society. Let me share with you some examples of the type of experiences that I've been able to participate with or help in terms of navigating this public realm to achieve a particular outcome. So when I went to law school in Toronto, and I volunteered for a legal clinic where students like myself would represent street-involved individuals in a variety of safe streets or municipal, basically defend them from municipal and provincial tickets like panhandling, loitering, jaywalking, and very simple offenses that only houseless individuals seem to be targeted with, right? It's a way to stop them from appearing and essentially existing within certain public spaces. So, we're ticketing people, at that time, the bylaw officers in Toronto were ticketing people who didn't have the money to pay for those tickets, or the ability to hire lawyers, defend against the tickets, and often didn't have the ability or the capacity or knowledge to fight them. And that's something unique to houseless individuals, right? Navigating the legal system is difficult. That's why lawyers exist. Even for lawyers, there's difficulties understanding processes and the ins and outs of these systems. But in the houseless context, we had individuals who would just keep accumulating tickets after tickets after tickets. And in many cases, the non-payment or the non-attendance at court would lead to warrants and then arrests, right? We're talking about many individuals, many of the most marginalized and vulnerable individuals in our society who would be imprisoned for jaywalking, for extremely inconsequential offenses. I had so many cases where once someone who was houseless had managed to work through the barriers or the impairments that they were dealing with in their lives and try to go back and find stable housing or employment, or even just to get their ID, they would face tens of thousands of dollars in tickets, and that would be a barrier for them to kind of move on with their life, to live a better, more flourishing life. And in the context of this, after I left this clinic, there was a revelation that a lot of the bylaw officers in Toronto at the time, and there's been criminal investigation and charges, would make up these tickets that once they had one individual's name to meet certain quotas, they would just issue a number of different offenses to that one individual. It would go to court, they would get convicted of these offenses, fees would accumulate, warrants would be issued, just to give you a sense of what was happening in Toronto at the time with individuals in this context. But in one case, my client was given a fine for panhandling in an aggressive manner. My client was houseless, and I remember meeting my client for the first time at a homeless drop-in shelter on Bloor in Toronto. And it was evident from the first 30 seconds that I met my client that he had a medical condition that caused him just to move his hands quickly and just be always high energy and talk fast and always want to move. He wasn't violent, he wasn't threatening. He just, his mind just worked in a certain way where he would be talking about dozens of different things at the same time, and he would move his body accordingly. But he was actually very kind and thoughtful, but it's just something that came across as abnormal in the context of how you deal with people day to day. But he got this ticket for panhandling in an aggressive manner. It was a couple of $100s. And he's houseless, he was Black, he was in his 30s, and I suspect that led for the bylaw officers to fine him. And a ticket of $200 for someone in his position was significant, and there were concerns that it may escalate things and lead to a warrant, imprisonment, things of that nature. But regardless, he had a right to defend himself. This ticket was, in my view, bogus, and I was there to help him. So I was, first or second year law student, and you have this sense that there are bad things that happen in society. Things are not fair for individuals like my client, but we have a court system here that should at least give standing to this individual. So I remember we go to the hearing. It's at the old City Hall in Toronto, and I remember my client was with me, and he's kind of moving and gyrating. He's very he's expressing a lot, and we go to the door that's the courtroom, and you should be aware that the courtrooms and trials and everything of that nature are open. Any member of the public can go. Everyone has a right to go, particularly those who are subject to fines that they're challenging. If you're the one who's essentially challenging something, or it's your trial, you have a right to show up. And it was clear to me, my theory of this case was that if my client shows up and the court sees him and sees his medical, it's very evident that the medical circumstances he lives in, this ticket's going to be thrown out, because sure, he's moving abnormally and he's very energetic, but it's far from being aggressive, far from being threatening, and there's nothing he can do about it. So I walked to the front door of this the courtroom, and I think immediately the prosecutor senses the same thing, that within a few seconds of a judge looking at my client, they're going to throw out this ticket and let him go free. And in response, she blocks his entry into the courtroom. So physically, she says he cannot enter this courtroom, and then she calls some sheriffs to do the same. And till this day, I've been in very contentious hearings. I've been in a variety of different contexts where, with very different prosecutors and government lawyers, I've never been in a situation where a Crown prosecutor will try to prevent someone who's on trial from entering the courtroom because they know their presence is going to lead to an instant tossing of the ticket in this case. But it was a 5 to 10 minute exchange with the prosecutor saying, my client has a right to enter this court room. We have a trial scheduled. You have no right to stop us. Trying to explain this to the bailiff. And maybe she thought because I was a law student at the time, my client was it was unhoused on the streets, that we would kind of relent and just accept it. But we persisted, and faced with the scenario, she ended up pulling the ticket. So we had a positive outcome. We didn't have to go and run this argument. We didn't have to really raise the issue that the prosecutor is preventing my client from attending the courtroom to defend himself. But not every unhoused person is in the same position of my client that day, right? Not everyone has the ability to access these, not even legal services, essentially support services, because I wasn't a lawyer. And not everyone has the capacity themselves to take these unjustified tickets that could have significant impact on their lives to court to fight, right? We're talking about tickets that no one else tends to get, particularly in a city like Toronto, like jaywalking and such, and ending up being imprisoned for that for sometimes 30 to 45 days at a time, perpetuating the cycle of poverty, incarceration, and just social marginalization. And for my client and these individuals generally, particularly the houseless population, the law does not seem to accommodate them, both in terms of the substance of the law, like what the law is and who it protects, but also how its institutions are run. In this case, how the prosecutor and the sheriffs in that courtroom thought their role was and what my client's rights were given his particular situation. And I'm working on a case right now, actually, with the assistance of Renee, dealing with the unhoused population here in Edmonton. It's around encampments and when the city of Edmonton can clear encampments. So as folks will understand, right now across country, including in Edmonton, there are far more unhoused people than housing availability or even shelter spaces. So in Edmonton alone, there are hundreds of more people who are forced to live outside, forced to live in very difficult situations, being completely exposed to the elements because there's insufficient affordable housing, supportive housing, and even shelter spaces. And when I mean that they'll be exposed to the elements when living outside, is that we're talking that just by the nature of the climate and the weather here in Edmonton, but across the country, where freezing temperatures are the norm this time of year, we're talking about people who are living outside in conditions that could kill them within a matter of minutes, right? We got wind chill, freezing temperatures, sometimes precipitation that just amplifies and accelerates that. So in Edmonton, we have hundreds of those individuals, and like anyone in that situation, they engage with it rationally. So if you have no shelter, you have no house, you have no apartment, you don't have an emergency shelter space, and you're outside, you do what is natural. You create your own shelter wherever there is space. And in Edmonton, that happens to be on vacant city lands, in parks, parking lots, wherever people can put up a tent, a lean-to, anything to protect them from the elements. Because when they're faced with the situation of freezing minus like 20, 30 temperature, even putting up a tent, even putting up a lean-to structure is better than the alternative, which is nothing. And we're talking about hundreds of Edmontonians who are forced to be in that position because of the failure of our government, not just our municipal government, but the provincial and federal government, to find shelter and housing options for these individuals. In response, the city of Edmonton, out of concern for what they consider this eyesore, has gone in and developed a policy to clear these encampments, even if there is no other place for these individuals to go. Even at temperatures where they'll be exposed to the elements and suffer grievous injury or death, right? That is the policy that the city of Edmonton has. At the same time, they talk about a compassionate approach to the houseless population, but you're placing them in circumstances where they're likely to be seriously injured or die. So naturally, folks in the community who are directly impacted raised concerns, spoke with agencies, spoke with folks like Renee and others, and we decided to bring a lawsuit against the city of Edmonton to say that we understand that there are concerns with encampments. We understand that the city and others don't like them, but unless you provide adequate alternative shelter, unless there is a better option, a safer option for these individuals, you must keep the encampments, because the aesthetic and the visual concerns that the city may have may be important. Removing these encampments can mean certain death for a large number of the most vulnerable and marginalized people within our society. So we're in the midst of that lawsuit right now, and just when you're in a lawsuit, there's various steps, right? There's speaking to individuals directly affected, speaking to experts, looking at the city's evidence, looking at their witnesses, and asking real tough questions to the policymakers and those who enforce a policy that causes harms to people you care about, unhoused people in this case. And it's just been illuminating how there is a recognition and a strong degree of compassion, I would say, for individuals in our client situation. But at the same time, this unwillingness to depart from a practice that they know puts these individuals in harm's way. There's even language in the city's operational guidelines of a trauma-informed approach to removing houseless individuals in encampments, and in the context even of -20 temperature or more, and with no alternative shelter space. And it just really boggles my mind that there can be a way to engage in that doesn't create more significant trauma. And I say that because we're in a context here in Edmonton where there has been record numbers of freezing deaths among the houseless population and amputations from frostbites. And medical experts, public health experts, emergency doctors have all indicated that there's likely a correlation, maybe not causation, between this encampment policy, increase in homelessness, this encampment policy, and these very sobering rates of death and amputation from frostbite. But there's this disconnect, as if, in theory, we understand that houseless individuals are human beings deserving of rights, but we're not going to move to do anything because the eyesore concern, the visual aesthetic concern is a greater issue for us than the lives of these individuals. And, like many people on this call or at this conference this week, that would cause real concern. And hopefully it causes you folks to kind of ask these tough questions and push back on the issues like this, but more broadly. And if for those of us who work in the legal realm, either as lawyers, students who are interested in becoming lawyers, or legal advocates, or experts and such, social workers, to work towards ensuring that our law does a better job of reflecting the experiences, the aspirations, and the dignity of all people in our community, particularly those who are most vulnerable or marginalized. Those are the cases that I have for you today. I really appreciate this opportunity because, when we come together in these kind of moments and hear stories from different people, I think it really provides an inspiration that we can work individually and collectively to make our communities better and more reflective of the values and vision that we have.
Thank you so much, Avnish. I don't know if you see the comments there, but people just saying we need more people like you. Thank you so much for your work, and then talking about all the barriers around disabilities and stuff like that, and access to housing. And thank you for your work, because I think one of the things I've learned this year, and prior to even the work with you, is that I didn't realize lawyers are actually not making very much, especially lawyers like you. You're really living the life of a student trying to do this important work. Seriously, I didn't, people don't really realize that. People think that lawyers just can have these resources to do this work, and it doesn't exist. And it's really, to take on these cases and to do litigation around economic rights is so challenging. And you are such a fierce leader with that. And I just really, really appreciate you and all that you do. And I want people to know and understand that about lawyers.
I appreciate that. And for people like me, it's really inspirational working with, like, Renee. I've been following Renee's work even before I became a lawyer when I was in school. And it's everything like Renee just said about me, I feel about her, but like multiple times. And I think a lot of people I know who are working in this realm in Edmonton and elsewhere draw inspiration from people like Renee. Like, we're on this path because people like Renee and others have allowed us to go down this path and approach these issues in this way. I'm being honest, Renee.
Well, thanks for making me blush at the end of this morning panel. I love you too, Avnish. All right.
Thank you so much.
I know you're heading into court, so you head out and we'll wrap this up. Okay. All right. I just want to kind of maybe tag a couple closing thoughts before we move off to the sessions for today. And I think, this conversation and having Marie-Josée, but also Avnish, and really thinking about this and these elements is, the housing spectrum goes from those emergency shelters all the way to like access to accessible housing, like I'm seeing in the chat. But, there's so many elements around this. And one of the learnings, and like I was kind of hitting on there with Avnish, is the litigation around for folks who are unhoused is really, really challenging. Not only just because they don't have the resources or don't have a space where we can access them all the time. Like I know at the John Humphrey Center, we've been seeing a lot of housing and encampment issues in Lethbridge and Wetaskiwin and Edmonton and Calgary, and being able to work with those folks to challenge things is hard because you can't always find them. It's transient. So there's challenges around how we do litigation and how we think out of the box to do that work. And I think Avnish is really setting that piece forward. And the other kind of things I just want to note, like the other thing about this and the unhoused population is we all have the right to sleep. And I think that's, it's, when you look at international conventions and stuff like that, it's almost like torture. It is torture not to have these spaces to sleep, but also like this need to find places to hide. When we were watching that Love in the Time of Fentanyl last night, and you think about people and the fear that they faced, I often talk to young people, especially young Indigenous men, for example. They live in fear of existing in society a lot of times, I've heard. And so when you're unhoused, you're trying to find these places where you can hide, where you can sleep. And that's serious stuff that we're constantly criminalizing people. So as we move forward, when I think about also the encampments and stuff like that, the narrative that is created within the governments can often be so harmful because it's a narrative that's where crime is. That's where all the, yesterday the word deviant kept coming up from in some of the prison conversations, and how that narrative is created and how problematic it is. And one of the things I learned in COVID with the encampments that happened here in Edmonton is I saw firsthand how like the violence that especially say young Indigenous women face, gender diverse folks face when they're unhoused, where encampments provide them some semblance of safety in numbers and community, and how that's really important for us to think about. So, when we see the dismantling of camps, we also then see the increase of potential vulnerability and violence against women, against gender diverse folks who don't have a space. And so there's all these things that we need to think about that we're going to be going in and talking about today. Today, we've got some really beautiful programming, and I hope you're able to engage. Like this morning at 10:30, we have the Center to End All Sexual Exploitation is going to be having the voices of survivors and talking about that intersection of poverty, criminalization, trauma, and sexual exploitation. It's huge. We're not often connecting the gender-based violence discussion to the discussions around houselessness And it's serious, and something we really need to think about because it escalates and deepens trauma reactions and responses. We also have a panel on student poverty and how that's going. I know it's not great these days, so that panel is going to be interesting and unpack some things. And then we also have arts and human rights, so conversing multiplicities with the Human Rights Research and Education Center starting off at 10:30. So I really encourage you to take all those in, engage in these conversations, remembering housing is this spectrum and remembering the vulnerabilities of people along that spectrum and where they fit in, but also just the narrative we have in our heads and how we engage and show dignity to people who are unhoused. Because I can tell you, like, poverty is not just about lack of economic resources. It's about lack of inclusion, belonging, to walk down a street every day and not even be considered human or looked in the eye or greeted by one single person. Think about how that affects our psyche and how welcome we feel and how we can navigate society. It's so much more complex. So thank you all. Thank you, Marie-Josée. Thank you, Avnish, for this morning. And thank you all for being here for part of these conversations. We'll look forward to seeing you throughout the day.